On her first day of work, a woman is told by her male supervisor that he believes women shouldn't work outside the home. Is the supervisor's opinion free speech, protected by the First Amendment, or harassment? Does equality for all mean limiting the speech of some?
We are men and women united in the belief that women must maintain the right to choose.
It used to be that it was minority groups and radicals who were pushing free speech interests. So there's been an interesting shift that now the main opposition in areas where people want to restrict speech is between claims of equality and claims of liberty of speech.
Not even in the United States is freedom of speech an absolute. There are always competing values, competing interests, and one has to decide how to adjudicate those competing interests in designing institutions and in creating legal rights.
Even so, freedom of speech is considered to be the most basic component of the First Amendment.
American rights of free speech are more extensive than those of any other country in the world. It really is the cornerstone, or one of the cornerstones, of a liberal democracy, to have freedom of speech.
But this freedom did not come without a struggle. In fact, ratification of the Constitution by several states was contingent upon the adoption of a Bill of Rights.
This comes out of a general feeling that there are such things as rights that inhere in individuals as human beings. What they are and how you specify them, how limited they are or how broad they are, was something that had to be worked out, and was, to the extent that they could do it in that generation, with the proviso that future generations would develop them further. And that certainly has been the case.
To understand what was new in American thinking about rights in the late 18th century, one really has to focus in particular on James Madison. Madison comes to the realization that in a republic, under the kinds of governments the Americans have been setting up since 1776, the real problem of rights is how do you protect individuals and minorities against the danger of majority power working instrumentally through government, and that's to say, especially through the legislature.
Madison was against the Bill of Rights. He later, of course, comes to write the Bill of Rights. He said, first of all, it's not the federal government's business to be in these areas of rights. That's for the states. Second of all, he said, what he called parchment barriers, that is, little words on a piece of paper, are never going to protect anybody's rights. If you enumerate rights, you're going to limit them. However, most people didn't agree with him, and it was required.
And throughout the 20th century, protections for free speech have increased.
Now, going way back to the First World War, it was really only in some cases that arose out of the Espionage Act in the First World War that the Supreme Court announced that the clear and present danger standard was applicable to freedom of speech. And this was really the beginnings of serious protection for freedom of speech in the country. People went to jail for saying things in the First World War that nobody would have even thought it possible to convict people in the Second World War, during the Korean War, the Vietnam War, of saying those kinds of things. Sort of opposition to the government, opposition to the war, and so on.
Department of Justice officials.
Even though in the McCarthy era there was a threat from congressional investigations and so on to freedom of speech in a serious way, this idea of criminal prohibitions against anti-government speakers really wasn't a factor even during that period.
Danger of the Communist Party.
Well, let's take a case that a lot of people are familiar with, the flag burning case that came up from Texas. This was a case where someone had publicly burned an American flag and had been arrested and prosecuted for that crime. And in that case, the arguments were basically that there was something almost sacred about the American flag, that an act of burning a flag is not really speech, that ought to be protected under the Constitution. And then on the other side, there was the First Amendment argument, which was there's nothing more important in the United States than the freedom to say unpopular things. And that what this person was doing very dramatically was making a political statement, albeit an unpopular one, but all the more reason it should be protected by the First Amendment.
Showing the people here in Greensburg is a Christian that will not back down.
Lately, free speech limitations have been driven more by equality concerns.
The arguments about hate speech are that minority groups and to some extent women are disadvantaged by hate speech, and so hate speech interferes with equality. But one argument that's been put forward in favor of hate speech is that many of the groups that most want to use this kind of discourse are groups that have been suppressed in the past, and that as a matter of equality and expression of these groups, it's important to preserve the opportunity to engage in this harsh kind of rhetoric.
There's no question but that different cultures, different countries, different peoples with different histories are going to institutionalize values like freedom of speech and freedom of the press in different ways. Germany, for example, with this experience of the Holocaust, is going to deal with the problem of anti-Semitic or racist speech. It's understandably going to deal with that issue differently from the way we deal with the problem of racist speech.
I think it's interesting that in Europe, a lot of countries have laws that make it a crime to deny the existence of the Holocaust. And in this country, that would be unthinkable if somebody said in a sort of bland way, well, I've surveyed the evidence and I really don't think the Holocaust happened. This would be clearly protected as free speech here. So the disagreement is over the edges of speech.
If the right to free speech is primarily for the sake of letting people express themselves and choose their own opinions and values, and if, therefore, it should be applied in a way that's neutral with respect to the content of speech, and that's how the U.S. Supreme Court has interpreted the right to free speech, then a whole range of expression must be protected by free speech.
Unless that speech is likely to result in violence.
If somebody says something to somebody else and it's likely to cause that person to fight, that can be punished. You don't want to say that if you utter the same epithet toward a 70-year-old slight woman that your speech is protected, but if you utter the epithet to a 20-year-old young man who might fight back, then it's not protected. To me, that doesn't make sense. It's grossly unfair. So I think one's got to kind of generalize and say, are these the kinds of words that might cause a substantial number of people to fight if they're addressed to that kind of person, and not get into whether this is a man or a woman, a child, somebody on crutches, somebody in a wheelchair, somebody who's very strong. A lot of statutes on which hate speech could be punished have been declared to be too vague. There was a strange case, I think, involving a young man who burned a cross on the property of a black family and was prosecuted under, I think it was a Minnesota law that said that if you did that kind of activity against minority groups, then you could be punished. And the statute seemed to cover too much, the Minnesota statute, but the Minnesota Supreme Court said that the statute only covered fighting words. 5 justices, in an opinion by Justice Scalia, said, well, let's assume that it only forbids fighting words. It only forbids fighting words that are racial or religious or in certain categories. And if you're going to forbid fighting words, you can't forbid some fighting words and not forbid other fighting words.
Violence or no violence, Rabbi Kahane or no Rabbi Kahane, we are going into Skokie by God this year.
Now, to me, this was a rather strange conclusion, but it was a decision that it was very discouraging about the possibility of singling out racial hate speech or religious hate speech or gender hate speech and treating it differently from other kinds of negative speech about individuals and groups.
Even less clear-cut is the court's position when an honest opinion is expressed to a captive audience, such as in a workplace.
There was a case in which a woman wore an anti-abortion button to work with a picture of a fetus on it, and she had made a religious vow to the Virgin Mary and Jesus to wear this button, and felt that this was sort of something that she was then compelled to do, but looking at the fetus was very disturbing for other workers. The court did say the speech was not protected, but in that instance the workers hadn't said it was religious harassment, they just said they were very disturbed, and the employer said, well, look, you've got to cover the button up or wear it only in your cubicle, and she refused to do that, and they decided, well, this is too disturbing to the work environment, therefore they can fire her if she doesn't make one of these accommodations that they're suggesting.
When developing the Bill of Rights, Madison acknowledged that equal to the importance of free speech was freedom of the press.
The opposition press was active in America from the earliest years in rather striking ways, namely the press as an opposition to the established government. There is a deep reservoir of thinking on the freedom of the press, although it wasn't what we would consider to be a complete freedom as we now enact it. In 1798, of course, the Sedition Act limited the press altogether, and people went to jail for criticizing the federal government, but that was very short-lived. And subsequently, we move into a modern period where the question of the limits and powers of a free press are continually being researched and considered by the courts and by the press world itself in an evolving way.
Break into Dr. Fielding's office was to satisfy the President of the United States.
The President wanted
In 1972, two Washington Post reporters uncovered the Watergate break-in.
I shall resign the presidency effective at noon tomorrow.
And here you had journalists kind of digging deeply into the bowels of government and bringing out many of the things that brought down a president. That was a lesson for both journalists and politicians. It gave journalists the lesson that this is what we ought to do, that we ought to be into ferreting out scandal. And for the politician, the lesson was, they'll do anything. There's no part of my life that's safe from the prying eyes of the journalist.
In recent years, there's been some question as to whether the press is using the First Amendment protections for their intended purpose. A recent survey conducted by the Center for Survey Research and Analysis at the University of Connecticut found that almost 4 in 10 Americans feel the First Amendment goes too far in the rights it guarantees. Prior to the 2000 presidential election, the figure was 2 in 10.
Jenny Jones, Jones.
The media has embraced the protections of the First Amendment, but has been unwilling to embrace any suggestion of what that implies in terms of obligation. I think the media, for example, when they call elections before the polls have closed and therefore discourage people from going to the polls, not just making a mistake. You know, they are seriously harming democracy, in my opinion. I call it the Jerry Springerization of the media. I think it's unforgivable. Every member of the media should not say, you know, well, this is what I have to do because of ratings. You're just a business trying to make a profit. However you can make a profit, great. Then why should you have constitutional protections?
A concept introduced early in the establishment of the free press was the notion that truth was a defense in cases of libel and slander.
The key was the Zenger trial in 1734-35, in which centered on the question of seditious libel. That is, the press free to criticize the government. The existing rule was that it was not, and that it was seditious libel to malign the government, whether what you said was true or false. And the Zenger trial in 1734-5 in New York came out with the verdict that truth is a defense.
I'm appalled that you're here in my town. Go away.
The difficulty with this is that there are differences of opinion as to what is true and what is false. If I say the governor of Massachusetts is a crook, that's my opinion. But is it a slander? Is it false?
And in 1964, in New York Times versus Sullivan, the court went even further in its protection of press freedoms when it ruled that libel of a public official requires proof of actual malice.
That was a libel case, and the ad at issue was a civil rights ad. And so by protecting the newspaper, they were really protecting people in the civil rights community from being bankrupted by defamation and libel suits that were filed under state law.
The court often has equality in mind in reviewing the constitutionality of state laws.
The real problem of rights now is how do you protect individual minorities within the states against the danger of state-based legislation that's going to violate their rights. Really, the most Madisonian part of the Constitution is the 14th Amendment and the modern incorporation doctrine, which has allowed the modern Supreme Court to apply the protections of the original Bill of Rights against the states under the authority of the Equal Protection and the Due Process Clause.
To this very day, we are concerned about how the federal government will relate to the state governments. So there's a continuous concern of these compromises, which, while settled to a certain extent, remain alive and will remain alive because they're really at the heart of how the system operates.
I think everyone agrees, every constitutional scholar would agree, that two of the most important things that the Supreme Court should do is maintain the system of freedom of expression and freedom of the press that we enjoy in the United States. Never let that be compromised, and also insist that government never treat any person, any citizen, any person at all as a kind of inferior human being whose interests count for less than anyone else's interests. And that, I think, has come to be the central meaning of Section 1 of the 14th Amendment. But insofar as contemporary constitutional doctrine is concerned, that, I think, is constitutional bedrock.
One is that the NEA is absolutely dedicated.
Exploit the fact that I am a nice person. They want to exploit the fact.
One form of expression which is not protected and where equality interests are at odds with liberty interests is obscenity. The trick is to define it.
Not very much counts as obscene. Virtually no writing, if any writing, would count as obscene, and it's not a wide category of material now. So really, although the definition hasn't changed too much, the amount of material that's been regarded as obscene has become sort of narrower and narrower as the years go by, and we know that there's just tremendous openness about this kind of material.
There have been attempts by feminists to restrict pornography on the grounds that is really not free speech, but it's a multi-million-dollar industry that degrades women and undermines the civic equality of women. This was an argument advanced in a series of federal court cases about an Indianapolis ordinance that would have restricted pornography in the name of the civic equality of women. And the federal court struck down those ordinances as a violation of free speech. Those ordinances were not neutral. They were passing judgment on the content of the speech.
Who in here wants to be strong for Jesus?
But in attempting to interpret laws in a neutral way, the court is often criticized by those who feel that such neutrality infringes on their rights.
In Jesus' name I pray. Amen.
The First Amendment has a provision that says there can't be any law respecting an establishment of religion, which means there can't be an established church or things like that, or prohibiting the free exercise thereof. That provides protection of free exercise of religion.
I think virtually everyone would agree that in the United States of America, the last thing we want to do, and the last thing we may do under our Constitution, is establish a church or a range of churches, have an official church or an official range of churches or an official denomination. That makes no sense in our context and would be constitutionally forbidden.
But many feel the court is creating a vacuum while trying to remain neutral on matters of morality and moving away from a value-based society.
But the idea that we should try to remove religious visions, religious vocabularies, the religious voice from the public square seems to me ridiculous in the American context, where 90 to 95% of the American people self-identify as religious believers.
If we attempt to banish moral and religious discourse from politics and debates about law and rights, the danger is we'll have a kind of vacant public square or a naked public square. And the yearning for larger meanings in politics will find undesirable expression. Fundamentalists will rush in where liberals fear to tread. They will try to clothe the naked public square with the most narrow, intolerant moralism.
I think that religious believers, whether they're liberal or traditional, liberal or conservative, should feel comfortable about speaking in the voice that's most natural for them and bringing their deepest convictions, which for them are religious, to bear. It's possible to have a vigorous constitutional doctrine opposed to the establishment of religion and still say there's nothing inappropriate about a religious voice in the public square.
You have no business being on a public school board.
In 1965, the court added privacy to the list of protections, reasoning that the freedoms in the Bill of Rights imply an underlying right of privacy. This interpretation has led to several controversial decisions.
People talk about privacy, they tend to be thinking in terms of abortion rights these days.
You've got enough problems of your own. Stay out of my womb.
The basis of Roe against Wade was an interpretation of the right of privacy, which is not in the Constitution. All the amendment says is there are rights not mentioned here, which are still retained by the people. And the court scratched its head and said, right of privacy of one. So you can't tell people they can't use contraception. And then it went on and said, and you can't tell them that they can't have abortions. This invention of the court became law instead of a constitutional amendment.
You know, and they're hurting other people, you know.
This clinic is open. This clinic is open.
And many constitutional scholars think that the Supreme Court exceeded its reach in 1973 in striking down restrictive abortion legislation. I emphasize many liberal constitutional scholars do. Not that anyone thinks it's going to be overruled anytime soon, but many of them suggest that the issue of abortion is fiendishly difficult, that people of good faith can reasonably disagree about how the terrible issue of abortion should be dealt with in the law.
The Supreme Court said that there was, under certain circumstances, a right to abortion. I agree with that outcome, but I disagree with the reasons that the court advanced. And the reasons reflect very powerfly the version of liberalism that says government should be neutral among moral and religious questions. What the court said in the abortion case was that no state can affirm in law some particular answer to the question, when does life begin? But what the court did was not really to be neutral among the religious views and moral views. It was to affirm a particular view and to reject implicitly another.
It's my sad duty to ask you to step aside on orders of the President of the United States.
It's a little dicey or tricky to say when, in fact, a policy should be left to the states. I mean, clearly, if we left the issue of segregation to the states, particularly the southern states, nothing would have happened. But I still think on issues of a woman's right to choose that we did have some of the same resistances. So the question is, do we protect a woman's right to choose in Massachusetts, but then take it away in New York or Pennsylvania? I think the issue Roe v. Wade should have been decided by the Supreme Court to set policy for the nation.
As First Amendment issues become increasingly complicated, the court is called upon more and more to balance rights of self-expression with the changing needs of society.
The Warren Court viewed the Constitution as an evolving, changing, living document. Now, in the process of doing good, doing justice, doing right, in a variety of places, they got quite some distance from the words of the Constitution. So there was this battle between people who thought the role of the court was to be restrained, to only strike down legislation, only strike down state laws when it was clearly at odds with the constitutional language or the clear intent, and those who thought that the role of the courts was to do justice.
In answering any such questions, I feel I have an obligation as a citizen of this country to preserve the Constitution, and I do not feel I can do so.
The position of the Supreme Court is not to do justice, as the judges understand justice. It is rather to make sure that the laws and political choices are in conformity with the Constitution.
On Common Ground, Framework for Democracy is a 26-part series about American government. For more information on this program and accompanying materials, call 1-800-576-2988 or visit us online at www.intelecom.org.